Hi, everyone, and welcome to today's webinar. I'm Margaret Jackson, a reporter at MJ Biz Daily, and I'm excited to be moderating and listening in on today's session where we will explore 280E challenges. For everyone watching who may be new to MJ Biz Daily, welcome. When this session is over, I encourage you to join our community. Follow us on LinkedIn and check out our great content and resources, which includes everything from breaking news to timely trend pieces and success stories and more webinars like this. To make things a bit easier, you can subscribe to our newsletter to get the latest news delivered right to your inbox several times a week. Now let's take a quick look at the platform we'll be using today. The On24 console you're looking at now can be completely customized. You can move and resize windows, making the video or slides larger or smaller as you like. You will also find an array of interactive tools. In the toolbar, you'll see a media player button for your video and volume, a Q&A box where you can submit your questions. We'll get to as many of those as we can at the end of the presentation. A resource list you can click through to download slides and related resources provided by our friends at Calix CPA. And perhaps most important is the survey icon, which you can click to share your feedback at any point during the session. Your input is extremely important to us. Before logging off today, please be sure to take a moment and share your feedback to help us improve future events. If you have any follow-up questions or need help with your experience, just send a question in the Q&A box or press the help icon to get further guidance. Before we kick off the conversation, I just wanted to share a little bit about our subject matter experts today. Justin Bautier and Jamie Jorgenstone. Justin is the CEO of Calix CPA and Jamie is the Chief Technology Officer. So we're in great hands today, and with that, I will pass it off to Justin.
Okay, great, yeah. Hey, so my name is Justin Bautier, CEO of Calix CPA. This may be your first time watching this webinar. I've done this webinar with MJ Biz and other publications quite a few times, and I've done it multiple times over the years, ranging from 471C, conversations about 471C, to what is 280E to begin with, strategies for mitigating 280E, challenging 280E. And then in the last couple of years, we've been talking about whether or not 280E even applies. Is it unconstitutional or not? Can we move forward without reducing deductions for 280E ahead of rescheduling? So in a sense, it's just challenging 280E. Can we move forward without paying tax on phantom income? Can we amend tax returns? So today we have a completely different format. There's absolute breaking news, which is pretty cool. In terms of a court case that we've been following very closely, New Mexico Top Organics, that was petitioned late last year in 2025. And it argues essentially, the big argument is whether or not 280E applies to businesses trafficking in substances that meet the criteria or the meaning of a Schedule 1 or Schedule 2 substance. So we'll get into a little bit of details there. Now, here, just like last week, the IRS, maybe 10 days ago, the IRS responded to the court case, and now they are countering. So again, to be clear, this is the IRS's response. It's not the judge. So you're going to hear the IRS's response to the petition, and we'll go over what that petition is. But to do that, I wanted to invite the brains of Calix CPA, Jamie Jorgenstone, to talk about that, because she has an incredible ability to synthesize information and has gone over the materials a little bit more in depth than I was able to. And she's also a partner, so we're partners, and she's she's usually behind the scenes, but today she has graced us with her presence. Thank you. So I'm gonna turn it over to you in a minute, but I think what I'll do first is talk a little bit more about what is happening currently. And then later on, after we present these, the IRS's response to the New Mexico Top Organics case, we have some commonly asked questions, like what are the questions that people ask Jamie and I most frequently when challenging 280E, amending tax returns, moving forward without reducing deductions for 280E. Cav, one thing that I need to say right now is that this is not an introduction to 280E. There is a wide variety of information online to educate you onto what 280E is. Probably not so much ways of knowing how to challenge 280E, except for, we'll go over one of them now, which is the one we're going to go over, but there's a lot of information on 471C. If you're new to filing your taxes and you're like, well, I need to get my taxes done right away, and you need a way to mitigate 280E, probably the tried and true way, one of the most conservative ways besides just paying taxes, 471C. This webinar is not about 471C, but you can probably go to Calix's YouTube channel and find some of the webinars that I have done in the past on 471C. And you should probably be talking to accountants that at least know that. If they don't know what 471C is, then they're not doing their homework, and you probably should seek somebody else out for help, bare minimum, okay? Now this is like bleeding edge 280E mitigation, okay? So we have been moving forward, challenging 280E, preparing tax returns without reducing deductions for 280E for a couple years now, and we're on our third year. And the primary argument right now that we use is, according to 280E, let me move or show you a note here. No, hang on. I'm gonna have to just do it. There's a little bit of a lag. So right now, one of the misunderstandings is that people believe that 280E applies to businesses that are trafficking in substances that are classified as a Schedule I substance. And that is the way the IRS is interpreting the tax code 280E. But if you actually read the tax code itself, there's an important distinction there. It doesn't say that cannabis or 280E applies to businesses trafficking a Schedule I or II substance that is classified as a Schedule I or Schedule II. It says if the substance fits within the meaning of a Schedule I and Schedule II substance. So if you look at this slide, there's a designation here. It says within the meaning of a Schedule I and Schedule II substance. Now, that coupled with the letter that came from the HHS, backed by a 250-page document by the FDA back in 2023, the HHS, which is a scientific body, and the FDA, which is a scientific body, clearly are telling the DEA, essentially, that cannabis squarely meets the definition of a Schedule III substance and not a Schedule I, Schedule II substance. Now, some of you may not know what the criteria is for a Schedule I substance, but what it is highly addictive. If a substance is highly addictive, highly dangerous, and has no medical benefit, that is the criteria of a Schedule I substance according to the CSA. And many of us know and have historically known, and this has been disputed for decades, that cannabis doesn't fit the meaning of any one of those. It does have medical benefit, it isn't highly addictive, and it isn't highly dangerous. So there are people now that are arguing that this isn't thought it would work. Okay, so there are attorneys that are arguing this point now in court, and the main one is the New Mexico Top Organics case. It is being represented by Nathaniel Pollock, and he put in the brief late last year, and essentially he's arguing that very same thing. Okay, so but now we have a response from the IRS, and that is what this is going to be about. I didn't mean to be long-winded there, but I wanted to make sure that I was clear about it. Okay, so essentially there's the two main arguments, and this is kind of also in response to what the IRS is saying, but the petitioner, which is Nathaniel Pollock in New Mexico Top Organics, is arguing that 280E doesn't fit the meaning of a Schedule 1 or Schedule 2 substance, and therefore 280E doesn't apply. But then the IRS kind of adds a little bit of a nuance when it responded, and it adds, well, who is responsible for making that determination? Is the tax court responsible for making that determination? So it kind of splits this into two issues here. One is, does cannabis fit the meaning of a Schedule 1 substance, or was Congress's intent to simply make sure that 280E applies to substances that were classified as? And then the next issue is, well, maybe the tax court isn't the place to be debating this. What the petitioner is asking the IRS to do essentially is decouple whether or not should be considered a Schedule 1 substance from the 280 aspect. So in a sense, almost like asking the tax court to reschedule cannabis or confirm that cannabis ought to be a Schedule 3 substance. And then the petitioner, which is Nathaniel Pollock again, he argued a couple of other things like, well, why does the controlled substances, why are we applying 280E when even Congress is no longer enforcing the rules of the Controlled Substances Act? And then the final one is kind of one that has been used for quite some time and has been debated as to whether or not enforcing the Controlled Substances Act on states that have their own cannabis regulation is even constitutional according to the Commerce Clause. So those are like four separate things that we're going to go into in depth. And thank you, Jamie, for being here, because I'm going to ask her to kind of take the lead on discussing each of these points more in depth and what the IRS's perspective is on that. So to do that, we're going to start with this first issue. Does marijuana fall within the meaning of a Schedule 1 or Schedule 2 substance for 280E? Jamie, you want to take it over?
Yeah, sure. Thanks. So I'm happy to be here. And I just wanted to start by saying, just kind of adding a little bit of context to what this presentation is meant to do. We're not lawyers, we're tax professionals. And that's kind of the intent of this presentation is what are the implications on, taxpayers of the currently circulating legal arguments, right? We're not giving legal advice, but it is important in this industry to understand the arguments out there so that we can, advise taxpayers about whether they can take these positions or not. As Justin mentioned, the big question is 280E within the meaning of Schedule 1 and 2. The taxpayer, the petitioner, argues that no, it's not, because the HHS says it's not. And, if you read the law, the DEA is bound by the HHS's medical and scientific recommendations, right? So the DEA is responsible for actually, rescheduling the drug officially or the substance. But it is bound by the medical and scientific determinations of the HHS, right? And that's really important. That was, Congress's intent was to split these duties kind of into two parts. One is the enforcement and one's the actual, science behind the scheduling. And so the taxpayer is saying, no, 280, it doesn't meet the definition, the criteria of a Schedule 1 or 2 substance. And we know that because of the HHS's, recommendation. And then the IRS, responds by saying it's on Schedule 1. So it is, it does meet the definition. So rather than really, diving into the criteria, which is really what the taxpayer asks the courts to do, the IRS is just saying, the tax court is not the right venue to determine whether a substance is Schedule 1 or 2 or 3. And if it is listed on Schedule 1 or 2, then it meets the definition, So they're really, go ahead, Justin.
Sorry, I just want to chime in. Yeah, like after reading the response, it really just was, it kept going back to what was Congress's intent. And you kind of touched on there that, well, Congress's intent was for the HHS to the DEA to take the HHS's recommendations and classify or reschedule a substance based on its recommendations. But in this case, it's saying, well, Congress's intent was to make sure that 280E applied to cannabis because it included cannabis on a Schedule 1 substance.
Yeah, well, there's a real clash between, that's one of we kind of, I think, go into it with argument 2, but they're very closely related here, which is what was Congress's intent, right? So did Congress intend, the IRS is saying Congress's intent was for the DEA to reschedule, to decide, they're the ones that ultimately are responsible for the actual administrative rescheduling. So the IRS is saying, okay, well, that was Congress's intent. And then, the petitioner, and we haven't touched on it yet, but I guess we should, Justin, the amicus curiae briefs, which are, we have a slide on it, but basically, when there's a court case, you can, friends of the court, that's what that term stands for, can submit their own briefs, in support of a party in the case. And so we have some people who have some really, smart, well-educated experts who have submitted briefs in support of the petitioner in this case. And the petitioner, again, that's the taxpayer that's, fighting the IRS here. And they go on to say, it couldn't be clearer what Congress's intent was. They intended for the HHS to be the one, deciding which substances meet the criteria. And where is that slide? That'd be a good one to bring up.
Yeah, let me see if I can find it right here. Well, first, let me introduce the amicus curiae or amici curiae, which is fun. It's a fun word once you get to know it. And it's kind of like, and I was really excited to see who those people were. So like kind of to reiterate what Jamie said, I had no idea. Again, we're not attorneys, so we don't really spend our day-to-day in this type of stuff, but it was fun to see that when the IRS responded to it, that that there were these like other kind of almost like briefs or almost like legal actions that are in support of the sponsoring lawsuit, Nathaniel Pollock's. And the people who were on those, this gal right here, Jennifer Benda and friends, Holland and Hart, we have followed her for quite some time. She's a very eloquent speaker. She's conservative in her approach, but she's been an advocate for this industry for like a decade. I don't know for sure, but she has done all sorts of work for the cannabis industry. And so when she came on the scene, I was like, oh man, like the IRS is in trouble now because, because she's on the scene supporting, she's in the corner essentially of Nathaniel Pollock and team. And then another amicus curiae is Nick Richards. And I've frequently quoted Nick Richards. He's been a close colleague of ours for nearly a decade. And he's been at it for well over a decade, speaking, advocating for cannabis businesses. And then his firm, Greenspoon Martyr, also did a brief. So this is an example of the brief. Colorado Leads is the company, and then Jennifer is their representation, and they're, they have put in a brief supporting Nathaniel Pollock. So with its own like arguments and whatnot. So it's pretty cool. It's pretty cool how it works. Now going back just one more though, is because these two are kind of so linked. Mm-hmm. We've got the primary issue, which is, does cannabis actually fit the meaning of a Schedule 1 or Schedule 2 substance? Or is the interpretation of 280E that cannabis is classified? 280E is for substances that are classified as a Schedule 1 or Schedule 2 sub. And then there's this, who has the deference on the scheduling determination? Is the IRS the place to decide whether or not cannabis fits the meaning of is a Schedule 1 or Schedule 2 substance? So then here we go.
Yeah, and so actually, could you go back to that other slide, the deference one? I think that was a good one to start. So, to add to go in a little bit more depth on what we're meaning by this is, so there's a code, right? There's a law that says exactly how rescheduling happens, right? It's a CSA. It determines, what is that administrative process. And what's interesting is that, part of that law really clearly states that the HHS, the DEA is bound by the HHS's, as I just stated, medical and scientific determinations. But then after the HHS does that, then the DEA is actually responsible for, the notice of proposed rulemaking and like kind of overseeing that process and eventually actually changing the rules and affecting rescheduling, right? And so there's a really big issue here is the IRS is saying because the DEA is responsible for that, then the DEA has deference. And then the petitioner is saying, since this is an issue on the criteria, right, for Schedule 1 and 2, this is a medical and scientific issue, and the HHS is the one that should be deferred to, basically. And that's really, both of those that's so important to understand because that's how each party is defining what within the meaning of a Schedule 1 or 2 substance means. So, Nathaniel Pollock, has drafted these arguments that say, within the meaning is very specific language. This is his argument, right? It's very specific language that invites you're supposed to read into the criteria, not just the list. Within the meaning shouldn't refer to a list, but it should refer to the criteria that define those lists. And an interesting note is that that language within the meaning is only used in the tax code. It's not used anywhere else in the U.S. code. It's only in the tax code. And he actually cites several examples of within the meaning used elsewhere in the tax code, specifically referring to like a definition of something, right? So within the meaning of X, Y, or Z, and it invites the reader to then go look to a different part of the code that defines something. It's not a list. And actually, very specifically in other parts of the code, the words listed in or listed on or identified under are used, meaning Congress knows how to write into the law very specifically, please reference this list as currently listed, right? And they didn't use that word, that language here. And so the argument is they would have used that language if they didn't mean something different than that language.
Yeah, and that's what the IRS's response to the Nathaniel Pollock's brief was, that that how could they have said it any other way? It was almost like they had said, they said that it was like, well, they meant classified as, because it's just part of like the speech or something to be able to include things under Schedule 1 or Schedule 2 substance. That was one of their big arguments, saying that that's what Congress meant. Congress meant classified. But then you look at actual other facts and circumstances, and you see that the Congress only uses this, and I'm reiterating, Jamie, what you just said, only uses that language in one place, and that is in 280E. Everywhere else, like Jamie said, they use listed on, listed in, or identified under, classified. Or they could have used classified, you know. But why did they use within the meaning? And Nathaniel, I love this little, I'm kind of going off topic a little bit, but he presents the idea that, well, maybe they wanted to capture other designer drugs under 280E, even though they were not listed as Schedule 1 substances. So what he's saying is that they wanted to cast a wider net to substances Congress might have missed, that maybe there was designer drugs, other drugs that are not currently classified as a Schedule 1 or Schedule 2 substance, but do fit the meaning of a Schedule 1 or Schedule 2 substance, and therefore 280E does apply. Mm-hmm. And now what Nathaniel's saying is like, well, but because cannabis doesn't actually meet the criteria of a Schedule 1 or Schedule 2 substance, according to the federal government itself, then 280E doesn't apply. Mm-hmm. And so this is I think their argument is poor there in terms of what Congress meant by within the meaning of. Mm-hmm. Okay.
Yeah, well, I think...
Hey, Jamie, let's go back one.
Yeah.
Because this is kind of a good, and for the folks that are watching this, I just put the slide deck together on Friday. So we're skipping around, but you guys can download this, and we're kind of jumping back and forth, but I'm going to let you take it from here. I wanted to make sure we talked about Loper Bright versus.
Yeah. I think this is really interesting. So within the context of, who should the tax court defer to, in defining what is, what the Schedule 1 or what is a substance within the meaning of Schedule 1 or 2, right? And what's interesting is, there used to be what was called the Chevron deference. That was maybe 40 something years old, Supreme Court precedent. That basically said that courts should defer to, the specialized agencies within the government, for their interpretation of law that might otherwise be ambiguous. The Loper Bright decision several years back overturned the Chevron deference. And what it replaced it with was, it's like similar in some ways and very different in others, right? So now the courts have a requirement to use or read the single best reading of a statute when they are, when they're making a decision. So they used to, defer to the agencies. Now the courts have a responsibility to that single best meaning of a statute. They have to determine what that is. Now they still do give deference to agencies, right? So they still do defer to agencies, but it's meant to be, they're meant to defer to these agencies, that have a body of experience, expertise, and if they've, kind of made these recommendations with good logic and good reasoning, right? That's all actually part of now the requirement of the courts is how they're deferring and when they're deferring. And they're also specifically supposed to give, heightened deference to agencies to which Congress has delegated authority, right? So that is very important here. So Congress has delegated authority to the HHS in making these scientific and medical recommendations. I feel like I'm saying that again and again and again, but I am. It's very important. And so an interesting quote from the Colorado Leads brief, the amicus brief, was what's here on the slide. Congress could not have used stronger language to delegate discretion to HHS because they say in the code that it's binding. The DEA, it's binding to the DEA, those recommendations. And so that's that position. They couldn't have used stronger language to delegate authority to the HHS, which is a pretty
Jamie,
big
can I chime in? Can I chime in? Did you when you were going over this, do you recall, it seemed like you pointed it out to me too, that Jennifer and team pointed out multiple times that this has been an ongoing issue with cannabis. There has been multiple lawsuits and legal arguments saying that cannabis doesn't meet the criteria of a Schedule I substance, and the DEA needs to move it from a Schedule I substance, and they have just outright refused. Is that ringing a bell?
Yeah, I mean, yeah, there's an extremely long history going back to the 70s and going back to like when the Controlled Substances Act first came into law, basically. And there was, and I don't want to get too into it because I probably don't like history, right? But the brief can be pulled. It's public and it can be read, and I would highly encourage people to like read through it. It's really interesting stuff. But essentially, the classification of marijuana has been being challenged since the 70s, and it's been, and courts have basically said the DEA is using, really not the right framework here. They've sent it back to the DEA, kind of look at this again, look at this again, look at this again, and it's just not happening.
They're not doing it. Yeah.
A really important piece of it is this currently accepted medical use. That's been being disputed for decades, that there is a currently accepted medical use, and people haven't been looking at the most recent evidence. And, it has been a very strong ongoing debate. And then we finally have this HHS letter, in recent years, which has given taxpayers, kind of this ability now to move forward, with something that we've all kind of known for all this time, right?
Yeah, I want to point out like the most recent example of how the DEA is abusing its authority essentially is that, and this is something we've been talking about for a long time, but the Office of Legal Counsel in the DOJ, which is the authority of the DEA, did a kind of an examination of the criteria that the DEA uses to decide whether or not cannabis has medical use, and they found that the test that it uses, its own 5-factor test, is impermissibly narrow, meaning like nothing is going to get through. Mm-hmm. And then of course they even said that it ought to use the HHS's 3-part test, which definitely confirms that cannabis has medical benefit. Mm-hmm. So
and that point, I want to chime in. That point's really important too, because in this case specifically, we're looking at, or the tax court is being asked to look at tax years prior to 2023, and 2023 is when the HHS formally recommended rescheduling. And so, it's pretty kind of widely agreed upon that the argument for not applying 280E is a lot stronger in 2023 and forward, because that's when this recommendation finally came out, right? And that's when the federal government itself, a part of the federal government recommended that, this be rescheduled and confirmed that, marijuana is scheduled incorrectly, essentially. But what's important is that impermissibly narrow test, right? So if you look at that and you look at the history, you can kind of go, okay, well, it's been incorrectly classified for a very long time, right? Especially at least back to the last time they performed this test, which was, I think, 2017. So that is really important for this specific case. And when you're looking at what years maybe you're considering, an amendment for, or what years you're considering, not applying 280E for if you're a taxpayer. Although the argument is probably stronger 2023 and forward, there is, I think, a pretty valid argument for going back further as well.
Yeah, exactly. Because, yeah, I mean, at least to potentially 2016, when another kind of this violation of the, now it's kind of important. So let's touch back on Loper Bright versus, Enterprise versus Romano, the Supreme Court case that overturned the Chevron deference, because that's a big change that happened relatively recently in terms of who is the authority. Like back in the day, the federal agencies kind of had the run of the place in that the tax court, or the courts in general, the federal courts in general, looked to the agencies as kind of like the governing bodies similar to Congress. So where there was ambiguity and that in the law that Congress wrote, then the federal agencies got the opportunity to kind of go in and include its own guidance. And then the courts looked to that guidance as having more authority. But once now we have a much different, like more states' rights Supreme Court, and the Supreme Court overruled that Chevron deference. That's what kind of came about it. And I don't know all the details about that, but essentially what it then said was like, no, listen, like you guys, courts, judges, you actually need to make these decisions. Like you take it into consideration. You should take in what the agencies say into consideration, but actually this is your jurisdiction, court. And that is one of the things the IRS was saying. They were saying like, no, this isn't our place to decide if cannabis is a Schedule 1 or Schedule 2 substance, and therefore 280E may or may not apply. This isn't, we don't have that jurisdiction. We're not the ones who should be making those decisions. And true, the IRS ought not to be doing that, but the tax courts might, they probably are the ones who need to make this decision based on the fact that they have more authority than the agency itself. So the IRS says, yes, cannabis is a Schedule 1 substance and therefore 280E applies. The tax court can say, well, according to everything that these experts have to say, and that have been doing this for decades, like Nick Richards and Jennifer Benda and Jamie Jorgenstone, that maybe they actually have a good point here, and that maybe we should take that into consideration, considering our tax team does a variety of litigation, and this may not be our area of expertise. Mm-hmm. But so I'm saying that they ought to actually really take these things into consideration. Alas, the judge might come back and say he might have a bad day and say, I hate cannabis, so therefore whatever the IRS just said, that's what's going to fly. But I'm not sure that's the case. And if you can see through all of these things that we just talked about, there's a lot of ammunition here to question whether or not 280 applies, because cannabis no longer fits the meaning of a Schedule 1 or Schedule 2 substance according to the HHS letter, the FDA, decades of challenges to that classification. And now when the IRS says, well, this isn't our jurisdiction, actually it is. The Supreme Court overruled Loper Bright, or the Chevron deference, and now we are looking to the tax courts to make the decision as to whether or not 280E applies. This is their jurisdiction. So I just feel like it's pretty flimsy so far, but go ahead, Jamie.
Well, I think it's interesting. I mean, I think it's a good point. The IRS does make a good point in saying, it's not, it generally wouldn't necessarily, be the tax court is not the right venue to reschedule. But then I think the briefs in support of the petitioner, those Friends of the Court briefs, also make another very good point, which is, essentially they're saying we're not asking the tax courts to reschedule, effectively reschedule marijuana. We're not asking, anything that a decision wouldn't apply beyond the tax code, interpreting these words, within the meaning. What does that mean? And I think that's a really important point, because that does, the idea is that does make it the tax court's jurisdiction, right? This is language that's only found in the tax code. That's a really important piece of the whole puzzle, I think. So then to make a determination on what within the meaning of Schedule 1 or 2 means, right, that language in particular, it doesn't have a ripple effect beyond the tax code and determining taxable income for these for taxpayers that are affected by 280E. It's not going to go on to then have affect how the CSA has to be enforced in other ways. It can stay isolated to tax, which is pretty important, I think. And so yeah, it's all very interesting.
Yeah, so and that's a good transition, because one of the things that it seemed to me the IRS was doing in their response was shouting what they've already said multiple times through various venues, that 280E applies as long as cannabis is a Schedule 1 substance. Over and over again, they were shouting it as if by shouting it, it meant it was like fact or something like that. And so then, and what it implies is, like, what they said in the brief itself, or in their response itself, is that cannabis or 280E applies unequivocally, or Congress unequivocally meant cannabis to be a Schedule 1 substance. And Jamie, I don't know if you remember, you pointed out something to me too, where it talked about, like, the Congress's intent was to punish illicit drug traffickers, people who were doing harm to society through their drug trafficking enterprises. That is what the point of the CSA is, and that is what Congress's intent is. And then the IRS parroted that and said unequivocally, Congress intended to punish illicit drug traffickers, AKA legal regulated dispensaries across the United States and other cannabis people, okay? And therefore, that's what's gonna happen. And so then this, like, conversation of Congress's intent. What was Congress's intent? Mm-hmm. And so that kind of brings me to the third point. Well, if Congress's intent was to punish illicit drug traffickers and enforce the Controlled Substances Act on cannabis operators, then why are they not doing it? JB, you want to chime in here?
Yeah, well, I think speaking to that congressional intent a little bit more, I think is a really interesting point, because we do actually know that was exactly Congress's intent with 280E, because it's written down, like, we have actual record of Congress writing out why they were proposing 280E and why 280E came into effect. And it was in response to a court case, a tax court case, where there was a drug dealer, like a bona fide, illegal drug dealer with a drug enterprise, that ultimately was able to take all of their deductions, right, on their tax return. That was the result of the case. Is they could take their deductions, they could write off, whatever, right, a drug dealer writes off, and reduce their taxable income. And then, there's this quote that it's, I'm not going to get it exactly right, but it refers to a sharply defined public policy against, like, drug dealing, right? And it's talking about drug dealers. It's saying it doesn't make sense to, allow these, these drug dealers to take deductions, and when they're costing, like, the American people so much money, and we've got this sharply defined policy, right? And so it's really interesting when you fast forward now, 40, 50 years, and you go, okay, where's that sharply defined policy now, public policy against against cannabis, right? Because it's not there any longer. And I think that's a really important issue here that this court case is exploring, is that the law as written reads one thing, but then in practice today, the reality is something completely different, right? You can walk down the street and you can buy legal marijuana in the vast majority of states now. There's medical programs, there's recreational programs, right? And there's not a sharply defined public policy against marijuana any longer, right? So that really was the intent of 280E. And so why is it still being applied to these state legal markets, right? That are very tightly regulated and are really, legitimate businesses. It doesn't really necessarily make sense anymore, right? So,
Yeah.
back to you.
Yeah, and the IRS's response, if I recall correctly, was that so in 2015 the Congress cut the funding out to go after these programs, and the DEA doesn't seem to be going after, the DOJ doesn't seem to be going after recreational cannabis either. So they're reprioritizing, and that's what the IRS says. It's like, oh no, if the DEA was fully funded, they would close all of these guys down, all these recreational shops down. There's no, they would squash the entire cannabis industry if the DEA was funded to do that. And therefore Congress still has the intent to do that, right? It's just that their priorities have shifted so that cannabis is a much lower priority. But Congress still feels that cannabis ought to be Schedule I substance, and therefore, should this Controlled Substances Act does apply, just like it always has. But does it really? Like, that's the question that I have is what is Congress's real intent now with the 36 plus states? I think it's even more than that. I've said that for like 5 years, 36 states with recreational medical programs. What is Congress's intent? Is Congress's intent for the Controlled Substances Act to still actually apply to these states that have their own cannabis regulation? Or is it clear with some of these changes that cannabis is no longer truly a Schedule I substance in the eyes of the Congress?
So as we're kind of getting a little bit close to the end of the hour here, and I know we need to do questions here. I know we could talk about this forever. I think really what I want to clarify is the point of this presentation is to talk about, what are, where does this leave the taxpayer, right? The taxpayer that has a state legal cannabis operation, and can you continue, after we've seen now the IRS's response, right? Can you continue to take this position that 280E doesn't apply? I think that's a big question, right? Can you do that? And that's what we can.
Is there a reasonable basis? The whole point of this whole thing is
there a reasonable basis? Can
you challenge 280E?
Yeah. And so a reasonable basis is a very specific tax, terminology. It doesn't just mean like, is it reasonable? It's not what it means. A reasonable basis means that a taxpayer is relying on a recognized authority to take a tax position. And it's a subjective. It's interesting because it is subjective whether something has a reasonable basis or not. But there's like these tiers. You can have what's called a frivolous tax position, which means you're just, it's like, I just think it should be this way. It's like there's like merely, maybe an argument for it, but it's not supported by any authority. Okay, that's frivolous. And that's how you get yourself into, penalties and a bad situation as a taxpayer. You're essentially ignoring tax law at that point. And then you can have a reasonable basis. And that doesn't mean you think you're definitely going to win if the position is disputed, but it usually is considered like a 20 to 30% likelihood of success. And a taxpayer can take a reasonable, like a position that has a reasonable basis, and they can generally protect themselves from penalties associated with an underpayment of a tax should the should the IRS, for example, dispute the position and disagree with it. Because that's really the big risk, right? Is are you going to have to pay the tax you otherwise would have paid, and also substantial penalties and interest on that underpayment. If you transparently disclose your tax position and why you believe there's a reasonable basis for that position, then you are generally protected from the penalties associated with any underpayment of tax. And that's really important to know here. So, what we've been doing with tax returns, where we've been, helping taxpayers take a no 280E position, is we file a very specific form. It's called an 8275. There's also a different kind of that same form called an 8275R. And we include very, very clearly, very, very transparently the amount of deductions, the reason, we point out 280E very specifically. We mentioned cannabis, we mentioned marijuana, and we include a legal write-up that's several pages long that summarizes the position. And so what that does is that very explicitly tells the IRS exactly what we're doing. It shows the position is made in good faith. I think it supports that there is, a reasonable basis for that position. And while we can't say there is absolutely a reasonable basis and that the IRS is going to agree with that, we can say, like, in our professional judgment, we believe there is. And that's why we're willing to file these tax returns for taxpayers, taking these positions. So even though the IRS now has submitted this response and they're very clearly saying they disagree with the position, that doesn't mean there is not a reasonable basis to still take that position, right? We can see from all these legal briefs that we've been discussing that there are, very well-educated lawyers, across the states that believe there is a good argument for this position. And so that's really important to know.
And again, when we're saying that, what we're saying is, like, you do not have to proactively pay tax on phantom income. That's what we're saying. Like, you do not have to proactively apply 280E because you potentially have a reasonable basis. The IRS might say you don't have a reasonable basis, but until that is proven through a tax court situation, it appears that you do. We do have reasonable based arguments based on authority here. Mm-hmm. And so we don't have a lot of time, and I apologize for being a little long-winded, this whole time, Jamie. But we have Q&A. We have some commonly asked questions. I'm kind of thinking, because we probably won't be able to make it through those, we have everybody's email, everybody who's here. You guys are going to get a follow-up. You'll be able to access this video, and then you can download the slide deck, which has those questions and answers. I think the slides do a very good job. And then Jamie and I will do another kind of follow-up Q&A for all those questions that we didn't get to today. You guys asked a lot of questions and we did not address them. And again, I apologize for my end of that. But other than that, please look to the slide deck. Please, subscribe to our mailing list, and we could do another webinar where we can answer the questions live.
Well, we have a few minutes. We could try a couple.
Let's do it.
Okay.
All right.
Yeah. Well, do you want to go ahead and ask from the people who ask questions now?
Sure.
Yeah.
So we have one person, Casey, who is asking about when the rescheduling to category 3 or schedule 3 will be effective. And until then, do they need to apply 280E and 471C at a federal return level?
Jamie, you want to take this one?
Sure, yeah. I personally don't know when it'll be rescheduled. I don't think anybody really does. Of course, there was that executive order, that demanded it be rescheduled as soon as possible. We've seen no action since then. The rescheduling has been delayed for quite some time now, and it's looking like it's just going to continue to be delayed. The point of this is that, there are taxpayers taking the position that 280E does not apply now, even before the official rescheduling takes place. And that's what we're discussing today. And so it's every taxpayer has to make their own, risk assessment as to whether they want to take that position now or whether they want to wait until an official rescheduling. But there's a statute of limitations for amending your tax return and for claiming refunds associated with potential overpaid tax, right? So you have 3 years from the date you either filed your return or the original due date of the return, whichever is later, to go back and file an amendment and say, hey, I actually think I calculated my taxable income wrong and I want my money back. And that's what, taxpayers are doing now is they're saying 280E doesn't apply. Oops, I filed my tax return applying 280E. Now it looks like, given these facts and circumstances, it shouldn't apply. If you want to go back and do that, every year and every day that passes, you're kind of losing the ability to go back and reclaim those disallowed deductions for prior tax years. And the rescheduling, as we said, could take many more years. It's very hard to say. So each taxpayer kind of needs to decide, do they want to keep paying all those additional taxes, or do they want to stop doing that now and try to keep their money?
Can I chime in real quick? So I see a question. Jessica came up. Are we still at reasonable basis now with given IRS response? And I want to say it's my opinion that yes, you still have a reasonable basis. We still have this is still the debate. Just because the IRS came back, that wasn't the judge that responded. That was the IRS that responded. And of course they're going to put up a fight. Can you imagine?
Right. The taxpayer is specifically suing the IRS right now. So the taxpayer presented their position. That was the opening brief that Nathaniel Pollack wrote. And now this is the IRS's response presenting its position to the taxpayer's argument. So we're still waiting for a court, the courts to decide on what they think. And then we do know that it'll be appealed no matter who wins or loses. So we expect this to be a long fight ahead of us.
One more. Should we do one more?
Yeah.
Sure. Let's see, what have we got here?
I see one. Has anyone tried to submit amended tax returns you're aware of to get 280E money back? Yes, we have filed, a good number of amended tax returns for taxpayers at this point. Our firm has, Calyx. And we have seen and this is in the slides, we didn't get to it, sorry, but about 50% of the amendments we've filed are still pending. We've been doing it for a year or two now, filing amendments for taxpayers, and they take a long time to get processed. It's like the IRS there was a report that just came out. It's 13 months is the average processing time for amended returns. But of the 50% or so that have been processed, we've had about a 70% success rate, meaning taxpayers have either gotten refunds back or have, reduced an outstanding tax liability successfully. And then all of the denials we've seen have been just that. They've just been a denial of the position. They aren't processing those returns. We have not seen personally any penalties assessed or any audits triggered from those amendments thus far.
No audits. Yeah. Let's.
I know we have more to say.
We can go on and on about it.
All right. Well, I think we have to wrap it up since we're at the top of the hour. But thanks again for everything. It was a great session. And thanks to all of our attendees for taking the time to join. We'll have this session ready for on-demand viewing shortly, and you'll find an email in your inbox when it's ready to view. Thanks again, everyone. Take care.
Yeah, thank you very much.
Thank you.